Oh, I finally get it. So if there's 10 men and 1 woman on a desert island, and the woman builds her house and she's out here fishing and catching her dinner and everything, and the 10 men, this is a community, they're all living in the same place. If the 10 men decide that she has to share her fish or just give it up, then they have a supermajority. The majority vote rules, and they got the right to do so by your comments, okay? If they decide that if she built her house, she's got to let them live there. Majority vote, they rule. If they say that she can't fashion her some clothing from leaves and stuff and she must stay uncovered, they got the majority vote, they rule. Or if they want to use her, decide that she's the only woman and they're not about to live the rest of their lives without a woman, she has to give herself up to them willingly or unwillingly, and they've got the right to do that. That's what you're saying. I mean, a supermajority, not even a 51% vote, supermajority. So she's got no rights. And if it applies here, why shouldn't it apply here? You can't have it both ways. The principle is the same, whether it be 11 people on a deserted island or 330 million people here in this imaginary border. 330 million against the 1. That's what the Bill of Rights is about. The people's right to keep and bear arms. 330 million people cannot delegate authority to any government to take away the right of the one person to have their guns, their arms. Marbury versus Madison. No provision of the Constitution is designed to be without effect. Anything that is in conflict is null and void of law. Clearly, for a secondary law to come in conflict with the supreme law was illogical. For certainly the supreme law would prevail over all other laws, and clearly our forefathers had intended that the supreme law would be the basis of all law, and for any law to come in conflict would be null and void of law. It would bear no power to enforce. It would bear no obligation to obey. It would purport to settle as if it had never existed. For unconstitutionality would date from the enactment of such law, not from the date so branded in open court of law. No courts are bound to uphold it, and no citizen are bound to obey it. It operates as a near nullity or fiction of law, colorable law. Now you say you've read this stuff. 16 AM Jurisprudence 2D. Read it. The general rule is that an unconstitutional statute, whether federal or state, though having the form and name of law, in reality is no law. You don't know what you're talking about.